What if I told you that one small misstep in the buyout of your childhood home could spark a legal firestorm? A mistake that could drag you into a painful, expensive, and emotionally draining lawsuit that forces you to sell the very home you're fighting so hard to save. This is the hidden legal trap of buying an inherited house, and way too many families fall right into it. I've seen these situations go from loving memories to absolute worst-case scenarios. But it doesn't have to be your story. In the video, I'm going to walk you through the critical steps you must take to sidestep this trap, protect your inheritance, and successfully buy out your siblings without blowing up your relationships. And just a quick heads up, this is for educational purposes and isn't legal advice. Your situation is unique, so please always talk to a qualified attorney about your specific circumstances. The trap I'm talking about is called a partition action. You'll need to burn that term into your memory because it's the ultimate trump card in an inheritance fight. So what exactly is it? A partition action is just a fancy legal term for a lawsuit filed by one co-owner of a property to force a sale. When you and your siblings inherit a house, you become co-owners, usually as tenants in common. This means you each own an undivided piece of the entire property. You don't get the living room while your sister gets the kitchen. You each own a percentage of the whole thing. Now here's the kicker. Any co-owner at any time for almost any reason can march into court and file a partition action if they want to cash out and can't get everyone to agree. If one sibling owns 50% and two others only owe 25%, even the person with the tiniest share has the legal power to kick this off. And here's what most people don't get. Courts almost always grant a partition. The law's perspective is basically that no one should be trapped in co-ownership against their will. Since you can't exactly saw a single-family home into 3 equal pieces, the court will order a partition by sale. This means the house gets put up for sale, often at a public auction. The fallout is devastating. An auction almost guarantees a lower price than a normal sale. To add insult to injury, the money from the sale first goes to pay court costs, referee costs, and lawyer bills before the heirs see a dime. You just don't lose the family home. Everyone walks away with less money and almost certainly torched relationships. The lawsuit is the trap. Now let's talk about how to build the shield that protects you from it. Your very first move, and honestly, the most important one, is to get a professional third-party appraisal of the property. This is non-negotiable. Forget what you think the house is worth, what your brother saw on Zillow, or what the neighbor's place sold for last year. To shut down conflict before it starts, you need an objective, legally defensible number. A certified appraiser will give the home a full-on evaluation to figure out its current fair market value. This number becomes official starting point for everything that follows and proves to everyone that the process is fair. And don't forget, the stuff inside the house might also have value and need its own separate appraisal. By starting with a professional appraisal, you instantly eliminate the number one reason families fight, the price. You're no longer bickering over opinion, you're all working from the same fact-based document. This one can stop a lawsuit in its tracks by building a foundation of fairness that's tough to argue with. Once you have that magic number from the appraiser, it's time for some open and honest talk. Sit down with your siblings and lay it all out. Tell them you want to buy the home. Don't ever assume you know what they want or what their financial position is. Some might be desperate for the cash, while others might be as sentimental about the home as you are. The whole point of these talks is to get to a formal buyout agreement. And I mean formal. It has to be in writing. A handshake deal or a verbal promise is worthless here and won't protect you. You need an attorney to help you draft a document that spells everything out. This written agreement should clearly state the final purchase price based on the appraisal, the exact dollar amount each sibling is getting, a timeline for buyout, including when they'll get their money, how you're planning to pay for it, your financing, any other details or what-if scenarios. Putting it all in a signed document gets everyone on the same page and protects all of you. It turns a messy, emotional family drama into a clean business transaction, which is exactly what you need to prevent legal problems down the road. All right, let's do the math. Figuring out the buyout amount is usually pretty simple, but you have to get it right. It's not just about the home's price tag, it's about the actual equity. The formula looks like this. Appraised value minus mortgage and other debts equal total equity. Then just divide that total equity by the number of heirs. If you want to buy out your two siblings, you'll need to pay each of them their money. You'll also take over the remaining amount of money that you have to take over the remaining mortgage yourself. Also, smart to account for any big expenses one sibling might have already paid for, like property taxes or a new roof, as they might be owed a credit. This straightforward math, all based on that appraisal, gives you a clear and fair buyout price. Coming up with the cash to buy out your siblings is often the biggest mountain to climb. You've got a few options, so it's worth checking them all out. First, the easiest option, cash. If you have it saved up, you can just pay your siblings directly. It's clean and fast. Second, and much more common, is getting a loan. But you can't just walk into a bank and get a normal mortgage because the house is still technically owned by the estate or trust. You'll likely need to find a lender who handles probate loans, estate loans, or trust loans. Think of these as special short-term loans built for exactly this situation. Once the title is officially in your name, you can then refinance that loan into a traditional long-term mortgage with a much better interest rate. Third, here's an option people often forget, a promissory note. This is a legal IOU where you promise to pay your siblings their share over time with interest. This can be a fantastic solution if you can't get a loan for the whole amount right now, but you have to do it right. The interest rate, the payment schedule, and what happens if you miss a payment must be clearly defined in a note drafted by an attorney to make it legally binding. You've got your appraisal, your written agreement, and your financing is ready to go. The last step is to make the transfer of ownership official and legally airtight. You absolutely need an attorney for this part to make sure it's done correctly. Your siblings who are selling will need to sign a deed, usually a quitclaim deed, which is the legal document that officially hands their ownership over to you. That deed has to be notarized and then filed with the county recorder's office. This recording is what publicly and legally makes you the one and only owner. It takes your siblings' names off the title and ends their legal rights to the home. Skipping this step or messing it up is a massive error. Without a properly recorded deed, your siblings could still technically have a claim to the property, leaving the door wide open for the partition action you've worked so hard to avoid. But critical note on taxes. A buyout can have tax consequences for everyone. For your siblings who are selling, they might wonder about capital gains tax. The good news is that heirs usually get what's called a stepped-up basis, meaning the asset is valued as of the date of death. They would only owe the capital gains if you buy them out for a price that's higher than that value. For you, the buyer, be ready for your property taxes to change. Many states will reassess the home at its new higher value, which means a bigger tax bill. This isn't universal. Rules vary by state, like in California, where Prop 19 has specific parent-child transfer rules, so you have to check your local laws. A quick chat with the tax advisor is a smart move to avoid any nasty surprises. Working through an inherited property buyout is a legal and emotional maze. If this video helped clear things up for you, do me a favor and hit that like button and subscribe for more tips on protecting your assets and your family. And most importantly, if this is your situation, the best thing you can do is get professional help. Trust me, the cost of hiring a good attorney to guide you through this is just a tiny fraction of the financial and emotional price of a partition lawsuit. Buying your childhood home from your siblings can be an incredible way to keep a family legacy alive. But as we've covered, it's a serious legal and financial deal that demands precision and care. Let's do a quick recap of the 5 essential shields against a partition action. First, get a professional appraisal for a fair, objective price. Second, create a detailed written buyout agreement that everyone signs. Third, correctly calculate every heir's share of the equity. Fourth, lock down your financing, whether it's cash, a special loan, or a promissory note. And fifth, finalize everything with a legally executed and recorded deed. When you follow these steps, you're not just buying a house, you're building a legal fortress around it. You're protecting the property from a forced sale. If you're protecting your investment, and most importantly, you're preserving the family relations that are worth so much more than any building. Thank you for watching.